All persons acting before the law, justice, the appeals, and outstanding and false and par within the Commonwealth. John A. For your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Morning. And welcome to the Massachusetts Appeals Court on this Monday, July 13th, 2026. I'm Justice Ditkoff. To my right is Justice Han, and to my left is Justice Grant. We were the panel for the remote case, and we will be for all 5 cases today. July sittings are not something the court historically did, but they've done it every year I've been on this court, and I have sat every July. And one of the great things about doing July sittings is that we get to have the summer interns come here. So I'd like to welcome all our interns from the Suffolk DA's office, the Middlesex DA's office, the Rappaport Institute, and the Judicial Youth Corps. After all the arguments, I encourage you to stay, and we will come and answer some questions and talk to you after the arguments are over. Everyone here arguing, well, almost everyone, strike that. I'll just go through how it works. Each side gets 15 minutes. There's no rebuttal. There's a clock there that will count down the time. When it gets to 90 seconds left, the light will turn from green to yellow. When time is up, it'll turn red, and then it will start counting up. If it's red, that isn't how much time you have left. That's how much time you're over. So if the light turns red, finish your sentence, but don't say anything else unless you're answering one of the judge's questions, in which case, please do finish your answer. We have read the briefs. We have looked through the record. We are familiar with the cases, and I would encourage counsel to jump right into their argument. All right. All that being said, I'll call the first case, which is Commonwealth versus a juvenile, number 24P778. I will remind the parties not to name the juvenile, and let's not name the brother either. Let's just call him juvenile or youth and brother.
Thank you, Your Honor. I was thinking of that last night when I was prepping. Good morning, Your Honors. May it please the Court. I am Joseph Schneiderman. I represent the youth. I plan to focus on the instruction about tow yard fees this morning. That's the second issue in the brief. If the Court has questions, though, about the other issues, I'm happy to answer them. The Commonwealth's requested instruction about the tow yard fee statute unconstitutionally diluted the burden of proof to compensate for evidentiary gaps at trial, and it requires a new trial for 3 reasons. First, the use theory and statement confirmed by the evidence was that he intended to pay to recover the black Dodge Dart. Every arresting officer and the booking officers found him with more than enough money to recover the Dart. Indeed, Officer Olivo quipped at transcript 2, page 139, they even have the money to pay. Second, the Commonwealth wanted the instruction to establish Hook and Go's rights, that's the tow yard, to control of the Dart because the Dart was registered to someone else. And actually, Your Honor, in solicitude to your point about brother, who is alleged to be my client's mother. The registration appears in the record at RA 65, and that is an essential element of robbery and of larceny from the person, which is control of another.
Was the propriety of the tow at issue?
I beg your pardon?
Was the propriety of the tow at issue at trial?
Not really, Your Honor. Manny Maldonado testified, I believe, at transcript 2, 104 to 6, that he had a contract from the 550 condos. What was at issue, though, was, it goes, though, to the youth's theory, because it actually takes me to one of my other points. Robbery and larceny alike require specific intent to steal. So even if the instruction went to the element of who has control of the Dodge Dart, the instruction still trickled over and affected the issue of intent to steal, because the jury would be left with the impression that my client is choosing not to pay and is indeed going out on a limb. Your Honor.
Why isn't it cumulative of Mr. Maldonado's testimony that in order to retrieve a vehicle, somebody has to pay the $165 tow fee, storage fee that's set by the state and show a driver's license?
Your Honor, I'm glad you asked me that, because that actually, the problem with the instruction is that it was not specifically correlated or tied into any of the elements of robbery or of larceny. This court and the SJC have recognized that burden-shifting instructions become uniquely problematic when the judge does not specifically tie them to the elements or to the concept of reasonable doubt.
Well, didn't the jury have to determine whose lawful possession the car was in to see whether it was stolen?
I don't quibble with that, Your Honor.
So doesn't the instruction tell the jury that the tow company has superior right of possession until the fee is paid?
Your Honor, that may well be correct, that the tow yard has superior possession, but one cannot divorce it from the other evidence at trial. And even though there's no objection to it, the instruction nevertheless directed the jury to infer my client's intent to steal because he had the money and was choosing for whatever reason not to pay.
What in the instruction that you're challenging says infer that this juvenile has the intent to steal?
Your Honor, the instruction itself does not say that, but the timing and placement of the instruction, which is what I was discussing a bit with Justice Grant a moment ago, in that the judge gives it, this is at transcript 3, page 85. Or excuse me, that's at transcript 3, page 69. Transcript 385 is the jury question. I apologize, Your Honor, I didn't mean to confuse you. But the timing of the instruction is what is problematic. The instruction is tacked on to the end of the instructions about robbery. The instruction is just left there in the ether without any connection to this is how you were to evaluate the youth's intent to steal.
But the instruction didn't say, you know, sort of parallel to Bankert, you may infer if you choose to do so that someone who takes a car without paying the storage fee is committing larceny. So doesn't that hurt your argument?
Your Honor, it doesn't say that, but this court has to evaluate the impact of the instruction as a whole. That is well established in the case law. And I think the impact of the instruction was to take it away from the jury about assessing my client's intent to steal, particularly in light of the evidence here, which is every officer finds him with more than enough money to recover the Dodge Dart. And my client even admits to one of the officers, that was my intent and my brother did something wild here. So the impact of the instruction, which actually takes us back to Bankert, because I'm with Your Honor, Bankert involved a slightly different instruction involving a presumption in the gas meter statute. The problem here is that the statute is not a complete picture of the law. The statute is not reconciled. That's the word the case law uses. It's not perfect. But the statute is not correlated to any of the elements. Without that correlation, it's left in the ether. And that actually takes me to my third point, which is the instruction invited speculation by the jury, which we know from, as I was saying to Justice Ditkoff a moment ago, transcript 83, page 85, record 78, the jury asks the question, what are the elements of robbery and larceny again? The jury were clearly struggling with this. If the instruction had been correlated to the element of robbery of control of another, or it had been correlated to intent to steal, I don't think we would be here. I would face a much more significant uphill.
Well, wouldn't you be arguing that what happened here happened in Bankert, which is the judge was too close to the ultimate issue in swaying the jury with the instruction?
Having heard
a better argument.
That I agree with, Your Honor, which is the instruction was, and that's a variant of what I was going to say, which is it is a needless embellishment here that, although it may have some support in the evidence, ultimately took an issue away from the jury and directed the jury to find against my client.
How does the storage fee statute, the language of the storage fee statute, influence the jury one way or the other about whether the juvenile was telling the truth when he said, I intended to pay, but my brother did something wild?
Your Honor, it leaves the jury with the impression that my client should be discredited, or indeed that my client was not credible or he was not genuine in his statement that he had the money and planned to pay. And every officer found him with the money. The booking officer at transcript 3, page 19, found him with the money. The sum impact of the instruction, which instructions must be evaluated as a whole, left the jury with that impression. It is not neatly akin to Bankert or akin to Little's, but the impact of it was still to remove this issue from the jury, as Your Honor was suggesting, and the jury were struggling with that. And I think in light of how there are jury questions here, it merits a new trial, and that also goes to the point I raised in my brief. I don't see a tactical basis on this record to acquiesce in this instruction. As the SJC recognized in Desiderio, there is no tactical basis to assent to or to acquiesce in an instruction that does not get the elements right. I do not see any tactical basis to assent to an or to acquiesce, excuse me, use the right words. I don't see a tactical basis to acquiesce in an instruction.
Well, since the defense theory was the brother was the criminal acting alone, then doesn't this instruction help with that theory, showing that the brother's actions were unlawful?
It may, Your Honor, but I think given how the jury posed a question and they were clearly struggling and how the instruction is just hung at the end, there's no correlation. The judge only says, because of the facts of this case, I'm required to charge you on this portion of Chapter 266, Section 120D. Just hanging it in the ether is not enough, and this court for many years has recognized judges should not be embellishing model instructions. I think Commonwealth versus Franchino in 61 Mass App speaks very closely to that. So a case should not be submitted to the jury on something less than proof beyond a reasonable doubt. This instruction would do that. If we follow Desiderio, then I don't see a tactical basis to acquiesce in the instruction. Unless the court has further questions, I ask that you reverse, and I thank you for your time.
All right. Thank you, Counselor.
Thank you.
We'll hear from the Commonwealth now. Whenever you're ready, Counselor.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Matthew Patalano on behalf of the Commonwealth. I will plan to spend the bulk of my time on the issue presented, but I will, if I have time left, address the other issues. So this instruction has been described as needless embellishment, but it served a very crucial point in this trial. As Justice Ditkoff pointed out, the act of ownership is relevant to whether or not something is stolen. As far as I'm aware, I've read over the statute a couple times now, the only thing that this went to was who owned the vehicle at the point it was taken from the tow.
Now hold on. The juvenile's family owned the vehicle at all times. The question was who had the right of possession, right?
That is correct, but either way, neither of the parties here owned the vehicle. There's nothing in the record that establishes that either brother or juvenile had any title or any claim of ownership. So as far as comparing the property rights, as it were, there's nothing in the record that either juvenile or brother had any property rights to the vehicle at issue. There is, again, mother may have property rights, but their relationship was not established at trial such that either of them could rightfully say, oh, I would have been able to claim the yard from the tow. Now,
Was it the Commonwealth's theory at trial that the juvenile and his brother stole the vehicle, or that they stole the storage fee, or both?
I believe it is that they stole, they improperly claimed the vehicle without paying the storage fee, which is until the storage fee is paid, the tow yard, as the instruction, which is why this is relevant, as the instruction lays out, the tow yard operator has superior title until the storage fee is paid, because again,
not title, right of possession, right?
Right of possession. My
Title was
apologies.
always in the family member,
Yes,
right?
Your Honor. My apologies. And I think the reason for that is because the tow yard operator, if enough time has passed where the storage fees have accrued such that the value of the storage fees is greater than the car, they could then, at that point, they could go through a process to claim actual title to the car. So for this, this is not needless embellishment. This property right is necessary to establish who the car is being stolen from, and that is the tow yard operator. Now, as far as what weight it has on the defendant's intent, I can't frankly understand what weight it has other than, if anything, to prove that his intent was to go and pay the fees. Without this instruction, it's unclear why he has the money in his pocket. What does the rest of that context mean? That context and that instruction is necessary in order to, if anything, to establish for the defendant that he was there for a legitimate purpose. Now, there's other evidence obviously going against the fact that he was there for a legitimate purpose of paying off the tow yard fees. But without that instruction, that defense doesn't make any sense.
Well, now I'm a little confused. I thought the point of the instruction was to tell the jury that the tow company had a superior right of possession until such time as someone paid the fees.
That is correct. So it is helpful for the Commonwealth because it establishes for the Commonwealth that the tow yard operator has superior possessory rights. But it is also helpful for the defendant because it establishes for the defendant, I have money in my pocket, I'm going there to pay the fees. Otherwise, without that instruction, it's unclear what the money would be for.
I get it now.
So it is helpful for both parties, and it establishes the necessary context for the jury. I'm not entirely sure how this could possibly be read to read in the defendant's intent to steal. I've read the instruction a couple different ways, and I don't see that in there. And repeatedly, it's been described as left in the ether, but I think the more accurate way to describe it is it's entirely self-explanatory. You read the instruction, it's very clear what it's describing, and it's not weighing in on other parts of it. And the rest of the jury instructions very clearly lay out the elements, lay out the burden is always on the Commonwealth. I think the judge repeated that 3 or 4 times, that the jury is always required to find the necessary elements.
I have a sort of a philosophical question.
Sure.
In what circumstances is it appropriate for a trial judge instructing a jury to essentially reach back and pull down a green book and read to the jury a portion of a Massachusetts general law?
So in my brief, I described it as 2 different steps. I don't see any case law, but I see no way of otherwise describing it. So a judge can always take judicial notice of a statute. The question then becomes, can they read it to the jury? And if it is relevant, I don't see any reason why they could not. Obviously, it'd be preferable to pull the parties to sidebar and say, can I read this instruction? I think it's relevant here. But if it's relevant to the trial, there's nothing to prevent that. I think alternatively, the question is, should they be required to pull the book off the shelf if it is even tangentially related? And I don't think there's any case law that establishes that they need to. And that's why I think the rest of the statute is not necessary. It doesn't provide any context that would have alleviated or would have corrected this burden shifting problem that the defendant complains of. I think the only thing that would have fixed that problem is the instruction that was given, which is, here are the elements, and you are required to, as always, the burden is on the Commonwealth. If there are no further questions on that point, I'll move on to the other issues, which I think merit discussion.
Okay.
So first, as far as the pill bottle identity issue, I discuss Renaud and Cuba quite a bit in my brief, and I just want to be abundantly clear that I think that those are the floor-setting cases. Renaud discusses if you don't have this much evidence, then it's not sufficient evidence, and Cuba says if you have this much evidence, then it is sufficient. If we were left with only the pill bottle, if there was no other evidence as to identity, I think we'd be much more similar to Renaud with the EBT card. But obviously in this case, there's a myriad of other evidence that puts him at the scene, including but not limited to the cross-identification. I won't say the first name, but the witness describes him almost getting hit by a car by first name.
Well, but the similarity of a first name wouldn't be enough to show identity either, would it?
No, Your Honor. So I think when you read that, I think that this is not necessarily a perfect identification, but when you mix that with the pill bottle, with the other things where he's found being, in a house hiding next to the car, and also with his statements to police, which basically say, yes, my intent was to pay the thing, it all allows, in the light most favorable to the Commonwealth, to establish that he was likely the party seen on camera. And again, the camera footage shows people moving in certain parts. Again, based on a first-name basis, it seems very likely that he was the one who was not ramming through the gate, but was rather the one almost hit by the car ramming through the gate. And then based on the tow yard operator's testimony, it seems clear that he was the one who went up to the tow yard operator and said, I have a gun, give us the car, basically, if that all makes sense.
In tying the pill bottle to the defendant in this, or to the juvenile in this case, you rely pretty heavily on Cuba. Would you agree with me that Cuba had much more specific facts that tied the defendant in that case to the print than we have here tying the juvenile to the pill bottle.
Yes, I believe, again, if it was the pill bottle in sort of isolation, I think you'd be much more in a Renaud framework. But I think the pill bottle is, if anything, the pill bottle corroborates the rest of the evidence that identifies. It's sort of the reverse.
And does it depend, does the value of the pill bottle depend upon the timing of its discovery to make it unlikely that the pill bottle was placed in the car at some time after the crime?
Yes, so that certainly weighs in for it wasn't placed afterwards. Had the car been sitting there for a week, obviously we'd be in a very different world. But where it was, I think, 30 minutes or so after the crime, that does tend to weigh in that it was not left some time afterwards. And also, Cuba, without much discussion, simply says it's unlikely that it would have been placed there earlier. I think that a pill bottle in a car is maybe less so than a fingerprint, but I think that logic still holds. I do agree that this is not necessarily directly on point with Cuba. It falls somewhere between the two, and it is the rest of the evidence that gets us over the sufficiency line.
The jury was given a picture of the pill bottle, but not the pill bottle itself. Is that right?
I believe so.
And I don't see a date on the photo. Normally a pill bottle would have a date, but that's
It
all
may
they
have
had.
on the other side of the pill bottle, but I believe they were only given the photo. So to that end, I think it was mostly to confirm, again, identity, address, things of that nature. But you're correct, had a date been given, that would have helped establish the time frame. But another thing that the pill bottle adds for us is another confirming point of the addresses. I believe the address on the Dodge matches the booking.
Oh, yeah, okay. I was going to say, don't give the address, but you weren't going to.
Yes,
You were just going to say
sorry.
it matches.
The address given on the Dodge, I forget the exact document, but the Dodge registration, I believe, is what it is, and matches the address given during booking and matches the pill bottle found in the Acura, so that establishes juvenile's address at the arrest, juvenile's address as it relates to the Acura, and juvenile's address as it relates to the Dodge car. So that ties all of these vehicles together in a way that no other piece of evidence really does. And so for that alone, even if it doesn't confirm identity, it establishes juvenile's ties to all of the vehicles in question. If there are no further questions on that, I would just move to the consciousness of guilt. I think it's pretty self-explanatory why hiding in a closet shortly after an arrest merits a consciousness of guilt instruction. This is sort of I think it's the Booker case that this is a pretty quintessential example of flight and hiding. And again, even without the hiding in a closet, he quickly darts away from the scene afterwards, gets in his car bumper comes flying off because he's in such a hurry to get out of there. So that alone would merit flight, but also the hiding in a closet, I would believe, would merit a consciousness of guilt instruction. And if there are no further questions on that, lastly is the vouching issue. I think that the closing arguments accurately describe the evidence and describe one possible interpretation of the evidence. I don't see any witness vouching in that instruction, but if questions on
It's just more a comment than a question. Both counsel in your briefs mentioned the prosecutor's closing argument saying you can see that on the video. It would have been really helpful when either counsel refers to a video to give us a timestamp of the video. This is a short video, but we have to watch it repeatedly to figure out where it is that it says what it says. The other thing is, thank you for your 16L letter.
Sure. And my apologies for not putting that site in there. I understand it's a short video, but I can imagine why that would be helpful. But if there are no further questions on that, I will rest on my brief and ask that this court affirm the conviction.
All right. Thank you very much. Thank you both. We'll take the case under advisement. I'll call the next case, Commonwealth versus KHADGI, number 25P1208. Take your time, Counselor.
Good morning, Your Honors. May it please the Court, Joseph Assone for the defendant appellant. The Court has asked us to read Commonwealth versus Mendez and to be able to discuss the case today. I wish that wasn't the case, but I guess we're going to have to discuss it. It's a case, obviously, about the finer points of harmless error analysis. And in that case, in the Mendez case, the Court found that the error of admitting the drug certificates was harmless beyond a reasonable doubt because the defendants took the witness stand in that case and they didn't contest that the substances that were seized were in fact drugs. All they contested is that it's for personal use, it's not for distribution. And so analogizing that to our case, to the case, assuming arguendo that there was a Creighton issue there and that the motion judge wrongly decided it, it's harmless error because the defendant chose to take the witness stand, and again, he didn't question or refute the point that this woman he's in a dating relationship with this woman, and therefore it's not just a simple assault and battery, it's a domestic assault and battery. But he took the witness stand and he testified that, you know, we have a dating relationship. But what he took the stand for was to refute that there was any assault and battery at all, whether it was a simple assault and battery or one involving a domestic victim. And so by doing that, he placed himself, in my view, in the same position as the defendants did in the Mendez case. And so it's harmless error. If there are no other questions for the Court, I would rest on my brief.
Sorry, just a sec. All right, well, thank you very much for your candor, Counselor.
Thank you.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Mallory Skrull on behalf of the Commonwealth. I will start out by addressing the Mendez issue. The Commonwealth does believe in any event that this was a harmless error. The Commonwealth, of course, does not concede that there was error below, but to the extent that there possibly was, this error would have been harmless in the Commonwealth's view. The Commonwealth sort of interpreted this issue more under a sufficiency lens, which is why we did not raise the Mendez issue initially. If the Court has any questions about that, I'm happy to answer. If the Court would indulge me, I would just like to discuss whether there was error. Again, the Commonwealth believes there was not.
Sure, go ahead.
Thank you. So the Court properly did admit the victim's statements made to the police officer, both under the excited utterance standard and as a non-testimonial statement. Defense, does not seem to meaningfully contest the excited utterance findings. But of course, those are reviewed for an abuse of discretion. There was no abuse of discretion here. The victim was clearly upset, still under the influence of the exciting or upsetting event at the time she made those statements to the officer. She was crying, she was sobbing, having difficulty communicating, and the officer just moments before had observed an assault in process. So I believe that clearly meets our standard for an excited utterance.
And there's no indication what the officer saw didn't implicate participation by anyone else. It was two people, one victim, one assailant, correct?
That is my understanding, Your Honor, yes. If there are no further questions on the excited utterance, I will briefly discuss the Confrontation Clause issue. So here again, we review for harmless error, but I do believe that the victim's statement about her relationship with the defendant, was properly deemed non-testimonial.
If the police officer asked the victim, what's your relationship to the defendant, how would that question be geared toward resolving an ongoing emergency when the victim's already in the ambulance?
Yes, Your Honor. I do believe, and taking the hypothetical, knowing that that's not exactly what happened here, should that have been the question? I think looking at the totality of the circumstances here, there is a scenario where that could still be considered non-testimonial, I think, in the way that it helps officers assess, to Justice Hand's point, whether there were other attackers, whether this was a random attack, whether this was targeted at this individual, without speculating too much, whether there were weapons involved, whether there is another suspect at large that could pose a further risk to officers or emergency medical technicians responding to the scene, or to the victim, other possible victims who were in the area. I mean, these statements, and here the officer's question, as he described it at the motion hearing, was what happened, that broad, all-encompassing question. He testified that he asked that question approximately 3 to 4 minutes after he came upon the scene of this incredibly violent assault, in his words. So I think to the extent that he asked that broad, open-ended question with the intent here, the non-testimonial intent of figuring out what is currently going on, what is the situation on the ground, I think that clearly meets our standard for non-testimonial.
The problem is that what happened is always the question, whether it's an emergency or not. And so we kind of have to pick from the circumstances that they'd already developed to figure out what kind of what happened that was. And where the defendant's already in custody and she's in the ambulance, what's your best argument that it's still a what happened so I can deal with it versus what happened so I can write my report?
Yes, Your Honor. So I think the best argument there stems back to the motion judge's specific findings about this issue, which are on the motion transcript, page 28 of the record. So here the motion judge explicitly said, and I'll quote the record here, the victim was in the process of being treated for medical conditions, and so while the officer was speaking with her, there are purposes, including ongoing emergencies, that would make this a non-testimonial statement. So the victim was currently in the ambulance. It's not clear from the record this all happened in a very small geographical area in a very short amount of time. The officer said from the time he came upon the assault until the time that he concluded his conversation with the victim, about 10 minutes had passed. The victim said that she had been assaulted for approximately 8 minutes before the officer came upon the scene. So
I have a question for you about how the testimony was elicited about the relationship. The question at the pretrial hearing was, did she tell you the relationship between her and the defendant? Wouldn't it be better if the prosecutor asked a non-leading question like, what did you ask her? And then we would know if the victim's statement about the relationship came in response to a specific question by the police officer as opposed to a more open-ended, what happened? So if it's the Commonwealth's burden to show that this is non-testimonial hearsay, don't they need to be a little more careful about how they elicit how the victim's statement came out?
Hindsight being 20/20, Your Honor, I would have preferred that the testimony came out that way with a non-leading question. But again, I do believe that based on this record, even with the officer's testimony being, I asked what happened and she provided this information, we do have all of the information about this circumstance that we need. The victim provided these statements to the officer within 3 to 4 minutes of the assault while she was seated, still at the scene, it appears, in the back of an ambulance. She was covered in injuries. Those photos were introduced at trial. She had bruising to her face, her extremities. I will say that the statement was also, to the extent that it goes to, the officers assessing the scene, whether or not there is an ongoing emergency, which I suggest is also a non-testimonial purpose, whether there could be other suspects at large, why this assault occurred, the need to assess this victim's medical needs, her need for medical assistance, This happened in winter. I believe it was a December assault. So presumably these individuals are, I hope, wearing, long pants, long sleeves, possibly coats. So it's not necessarily immediately clear to the EMTs who are treating this woman, nor to the police officer responding, to what extent she is injured. As I mentioned, they can see her face. They can see bruising to her face in that moment, but if she was covered, and it seems a reasonable inference that in December she would have been wearing some sort of long clothing, it's not clear just from a visible or a visual examination what her need for medical assistance may be or to what extent she needed that medical assistance. So I think here we can clearly say, based on the motion judge's findings, that those findings, if there was error, it was harmless beyond a reasonable doubt. But I think based on those findings, there was no constitutional error here. The court has no further questions. I would ask that you affirm the judgment below, and I will rest on my brief.
All right. Thank you, Counselor. Thank you both. We'll take the case under advisement. Let's let Counselor get situated. All right, calling the next case, Commonwealth versus Jackson, number 25P933. Whenever you're ready, Counselor.
May it please the Court, my name is Charles McGinty. I'm appearing here for ORETTE Jackson. The issue here is whether a statute which penalizes possession of a firearm by a licensed person while under the influence of alcohol is constitutional. The statute itself is indifferent to the circumstances. The statute requires no finding that the firearm be displayed, brandished, or made the subject or the object of a threat, nor is there any relief here if it is merely passively possessed. In order to pass constitutional scrutiny, the test set out in Rahimi and other Supreme Court cases indicates the Commonwealth has the burden of showing that the regulation is consistent with the nation's historical tradition of firearm regulation, that it requires well-established historical analogies, which in purpose and operation is similar to those from the colonial period. Now, I expect that the Commonwealth will raise an issue relating to the recent case of Himani, which was the subject of supplemental briefing. In Himani, the court indicated that it was not addressing whether it was lawful to ban those who were presently intoxicated. What's interesting about that is, of course, Himani was an as-applied case. The court remained within the boundary of that as-applied case, and it indicated that its ruling was narrow. But in fact, with the Himani decision came a vacating of the Third Circuit's decision. And in vacating the decision, the court not only was vacating the part, the court was vacating a decision which both held that the statute as applied in that case was one that as applied would provide relief to the defendant. It vacated the facial challenge that the Third Circuit had applied.
Was it a vacate and remand for reconsideration in light of? In
light of Himani. So Himani's presentation as being simply an as-applied case, that it was sort of a modest presentation of what was at issue here, it makes no sense here if what the court did in the wake of Himani is to say, reconsider, Third Circuit, the ruling that a facial challenge failed in the wake or in consideration in the light of the Second Amendment. So here's the crucial point, I think, that needs to be made here. And I'm going to refer here to Commonwealth versus Kelly. Quote, firearms do not cause harm merely by existing. There's a difference, both in common sense, but also in the historical record. There's a difference between a gun's presence and its improper use. The Commonwealth has indicated or has pointed to some few measures, one in the 1700s, one in the 1600s, regarding the discharge of firearms while the person was not under the influence, but while the person was intoxicated. Those measures, which were for limited areas and for a very limited period, are the only indication of restrictions that were applied to the carriage of firearms while intoxicated, and they depended upon misconduct by the actor.
Aren't we,
Sorry, go ahead.
in order to determine the relevance of those colonial statutes, wouldn't we have to do fact-finding to decide, you know, how drunk were people all the time? Were they drinking alcohol because there wasn't clean water? In what circumstances did they store their gunpowder separately from their muskets?
Well, the court,
Don't we have to make factual findings? Shouldn't that be best done by a judge in a trial court first?
As in most cases, the reviewing court is subject to the record that was made below. Here we look to Himani, and Himani, what the court did is to take the record that was presented, and it went through each of the templates. Drunkenness. It went through the ones that related to the surety laws. It went through practically each of the analogs that the Commonwealth presented here and found them deficient because, for example, with the drunkenness laws, it wasn't simply the person was drunk in the way that we usually describe. The drunkenness laws were about persons who were habitually so dependent upon alcohol that they couldn't function in their daily lives. They were subject to all manner of the impact of persistent and deep alcoholism. They weren't drunk in the way we ordinarily regard it here. And in the court, when it makes a description of what the drunkenness laws say,
Counsel, do you agree that there was a tradition of locking up and disarming people who were highly intoxicated in colonial times?
No, I don't. And the reason for that is that when the court in Himani describes this, they're talking about persons being detained, and in the description they talk about persons being detained for the night or for such time as they come to sobriety.
Right, but wouldn't they be disarmed while that was happening?
The disarmament is a conceptually separate thing. The fact that someone has property.
I thought in Rahimi they specifically said that you could take people who were locked up altogether as being disarmed, that was a valid...
Rahimi did not say that. The Third Circuit had said that. Rahimi did not say that. What Rahimi
What about at page 699, where it said, if imprisonment was permissible to respond to the use of guns to threaten the physical safety of others, then the lesser restriction of temporary disarmament also is permissible?
Well, what we also have, though, in Rahimi is the following passage. There was a criticism of the application of 922G3 because the statute, quote, makes no difference whether, I'm referring now to Himani, whether he never misuses a gun while intoxicated and never poses a danger to himself or others as a result of an unlawful act. So in Himani, the court both says we're making a modest decision, it's only an as-applied decision, but puts in there language which suggests that there's going to be consequences to a facial challenge. Because if the person never misuses a gun while intoxicated, we're talking about this case. Now, what they're not saying is that the mere presence is sufficient because the only colonial templates that existed, such as they were templates that regarded the misuse of the firearm, the discharge of the firearm. So it may be incidental that if you take custody of a person for purposes of having them dry out, you're taking custody of their property, which may include a firearm. It's not because they had a firearm. It's simply because they were intoxicated, and the court made plain that the intoxication that caused that kind of interaction was one where the person was severely impaired, and it was necessary to hold them for such time as they retained some measure
Right,
of
but
sobriety.
couldn't
So there's
we
no license
construe
here.
this statute as requiring that level of impairment?
I think that the Supreme Court sets out that if the drunkenness measures from colonial times set a template, it's on their terms. It's the understanding from the colonial period that binds us, whether we're happy with that restriction or not. That's the Supreme Court boundary. So what they're saying is, was it done in a manner consistent with how it was done during the colonial period? And in the colonial period, the measures that related to drunkenness, according to Himani, were ones where there was deep impairment of the person such that they couldn't function. That's what binds us here.
Right, but why can't we construe 10H as also requiring that level of intoxication?
Well, then we get to the issue of what the actual standard under 10H is. It's under the influence. The under the influence standard, as we know from the case law, doesn't require that the person be drunk. It's simply that it has some effect on them.
Well, there's just...
Now,
Preclude that, right? It doesn't preclude that a person is drunk. Under the
No,
influence
it-
covers a spectrum potentially that goes from,
That's
as
exactly
you
right.
suggest, a
That's
lesser
exactly right.
standard to a severe impairment.
But the element of sufficiency is not drunk. It's not so impaired that, the colonial standard, it has some effect on the person. And if we look to the colonial template...
But it doesn't have to be. That's just an appeals court case. Why can't we construe 10H as requiring the constitutionally required level of drunkenness?
Because the statute doesn't allow that. Because under the influence, as the instruction was given in this case, under the influence was not that, did not meet that standard. So we're bound by the record here. If the court wanted to provide relief to Mr. Jackson, he wouldn't be offended by that. But in terms of a decision whether the statute is constitutional on its face, I don't think that aids anything here. And, you know, we have to go back to...
You agree it's a facial challenge you're raising?
It's a facial challenge, yes. And, we have to keep going back to what was said in Rahimi. Quote, even when a law regulates arms bearing for a permissible reason, it may not be compatible with the Second Amendment if it does so to an extent beyond what was done at the founding. Those are hard words, to the extent done at the founding. And whether one might, as a policy matter, think that's prudent or not, there's a handcuffing here of the lower courts by a standard that says we look backwards. And when we look backwards, we embrace the standards and the meaning that existed from a prior era. And here, if you look at the penalty that's imposed, the Supreme Court said that with respect to any offense that related to firearms, they were punished, quote, with a small fine and forfeiture of the weapon. This case involves a 2.5-year committed sentence.
Potentially, or a fine, correct?
Or a fine.
Right.
But we go from there and we look at Commonwealth versus Kelly. In Commonwealth versus Kelly, there was a Second Amendment challenge to a statute that penalized the discharge of a firearm within 500 feet of a residence. The court found that it escaped Second Amendment condemnation, sort of a tough word, but it escaped scrutiny of the Second Amendment because the penalty was 6 months max. And that was a penalty that was within a boundary that was consistent with the colonial period. That was the SJC. It contrasted that 6-month period with a 2.5-year period, which is exactly what's at play here.
Counselor, before you run out of time, your friend concedes that you didn't need to raise this in a pretrial motion, but it's not obvious to me why that's so. Could you argue why this claim is preserved even though it wasn't raised below?
Well, because the Supreme Court has indicated that it is retroactively available for cases that were open during the pendency here.
Oh, it's available, but normally you have to, a claim of facial invalidity needs to be raised by a motion to dismiss. It can be waived by not being raised properly.
So, I mean, this court could remand the case for further record in the trial court, but in terms of barring relief here, on that ground, I think the court would be constrained in its ability to do that. So I don't see that as an option here.
So to succeed on a facial challenge, you'd need to show that there's no set of circumstances that exists under which 10H would be valid.
Right.
And in thinking about that through the prism of colonial statutes, would we have to conclude that there was never a circumstance in colonial times when someone was so drunk that his guns were taken away?
Well, you mean under a law? Because under a law, I mean, people have been scrutinizing this for a long time. There's a lot of cases on this. None of them had found any restraint on possession by a person who's intoxicated unless there was a firing of the firearm. There's a, you know, to the extent the Supreme Court talks about how we look to the era and see what it responded to, there's utter silence on the disarming of persons who are not involved in misconduct.
But you do cite to, or at least reference, the cases that involve taking guns from intoxicated militia people or on-duty soldiers. And you, in your reply brief, talk about those as being inapplicable because they refer to military discipline. But to Judge Grant's point, isn't that a set of circumstances in which intoxication is a reason under colonial precedent for taking away a firearm or for punishing that conduct?
But if we look at Rahimi, it talks about whether the law regulated it for the reason and to the extent it was done at the founding. The reason for constraints on militiamen was military discipline.
And where is that? Where do I find that?
Well,
point?
what you'd find it, there's not a specific case, as far as I know, that says that, but it is, if you look to what the reason was for that, it was military discipline, not a hint that it provided a constraint on carriage by a person who was intoxicated who was civilian, where presumably there was a sort of a greater population potential for that if it was viewed as a concern during the colonial period. So one can infer that the absence of a measure that addresses a gun carriage while a person is drunk, not merely under the influence, is drunk, the absence of that is affirmative evidence of the lack of any analog that would support the current law.
All right, I think we're going to have to leave it there unless there's further questions. All right, thank you, Counselor. Very complicated case and really interesting one. Thank you.
Good morning. May it please the Court, Travis Lynch for the Commonwealth. With me is the trial prosecutor, Hillary Sullivan. This is a facial challenge to Section 10H. As we outlined in the brief, there are any number of historical laws that show that a law that has the effect of forbidding someone who's presently intoxicated from carrying a firearm is consistent with the Second Amendment right. As we said in the brief, there's the Rhode Island law that banned shooting guns at night and at taverns. There's the New York New Year's Eve law that banned shooting guns on that occasion. There's a Pennsylvania law that banned shooting competitions at taverns. There's the militia laws that said that soldiers can't be drunk, as well as laws that tried to prevent soldiers from being drunk by banning alcohol sales near encampments. And then I think what's really telling is that drunkenness was an offense starting in 1606 in England by that parliamentary statute that's cited in the brief. And it could be punished with a fine of 5 shillings or 6 hours in the stocks.
But wouldn't that require considerably more intoxication than we've interpreted this statute to require?
So there's 2 responses to that. This is a facial challenge. So you'd have to find that the only challenge here is the statute could never be constitutionally applied. So I don't think that really matters, quite frankly. The other point that I would make about the definition
that matters to how we write it.
Well, sure. But the other response to that is the definition of under the influence necessarily involves the impairment of the defendant's ability to safely carry the firearm. So the notion of safety is already built into our interpretation of the statute. And you're only under the influence for purposes of this statute when you cannot safely carry the firearm. The statute does not ban you from drinking a beer and then carrying a loaded firearm. It's only if you cannot safely carry it. And the judge instructed the jury in these terms during this trial. I mean, again, the facts don't really matter here because it's a facial challenge, but on this record, the jury had to find beyond a reasonable doubt that the defendant's ability to safely carry the firearm was impaired by consumption of alcohol. And that safety concern, I would submit, is consistent with history and tradition. The particular amount of intoxication, I don't think that it really matters, quite frankly. But the point is, it was permissible to forbid someone who can't safely carry a gun because they're drunk. That was perfectly permissible back before the adoption of the Second Amendment. It remains so today. And that's not to mention the fact that in 1867, there's that Kansas law that's cited in the brief that actually used the term under the influence. It bans carrying a pistol while under the influence. It's not actually settled when the cutoff is.
I mean, I like using stuff before the 14th Amendment, but that's pretty far out, isn't it?
It's right before.
I mean, it's right before, but
right, it's right
on
before.
The edge.
I mean, but again, I believe in the Seward case, the court says, well, as long as what happens after the adoption of the Second Amendment is consistent with what happened before, it can count. Our point is, it can count. It's not the sole point here. It's just that I think the defendant is taking too restrictive a view of what historical laws count towards history and tradition. So I would also submit that the fact that they used the term under the influence in that Kansas statute also supports our position. But again, I think it's really important to remember what the definition of under the influence is. It's tied to the defendant's ability to safely carry a firearm. The Hamani case doesn't change anything. I acknowledge that the Harris case was a summary certiorari grant, vacated and remand. I don't think that any aspect of the facial challenge is really at issue in a remand in that Harris case because it wasn't a facial challenge in Hamani. And there are those other courts that are cited in my brief that say that Section 992G3 is facially constitutional. No one has ever held that Section 992G3 is facially unconstitutional. That seems to be a consensus view. And I've cited other cases in the brief, in the opening brief and in the supplemental brief. There's a Virginia case, there's a Washington case, and there's an Ohio case that support our position that a law that does what this statute does is constitutional.
So I know the Second Amendment's the sexy issue, but I think we really do need to talk about whether the statute requires knowledge.
Yes.
And whether there was enough evidence of that.
So yes, we can move on to that. So we disagree with the trial judge forcing us to prove at trial that the defendant knew that the gun was loaded.
Did the defendant need to know he was possessing a gun?
Well, I don't think that that's what the statute, well, we didn't actually go that he was possessing, it was that he had to carry it. But I don't
Does the defendant need to know he's carrying a gun?
I don't think that's the issue here. But I don't, if we had to prove that, I think it's pretty infringing.
I mean, it's an issue in the sense that to win on the legal issue, you either have to convince us that there's no knowledge of any sort required, or that for some reason you're required to know it's a gun, but you don't have to know it's loaded. So
the plain text,
I'd like you to pick one of those and defend it.
The plain text, I don't think the word knowing is in the plain text of the statute.
It's not.
So as a matter of plain text, I don't think that there's nothing in the statute that says that. So
But is that how we should interpret it? That if someone puts a gun in a box and hands the box to his now friend who's, .08 intoxicated and says, can you bring this box over to someone, that's a 2.5-year crime, and the fact he had no reason to think it was a gun is not a defense at all?
I can see, I can see how that would be a concern, but again, that's not the issue here. The issue is whether he had to know that it was loaded, and again, the statute doesn't say that.
All right, well, if he has to know it's a gun, why wouldn't he have to know it's loaded? If the fact that knowingly isn't there doesn't end the argument, then what's different about knowing it's loaded than knowing it's a gun?
The whole point of the statute is to ban people from carrying loaded firearms. If it was a defense that I didn't know that there were bullets in it, that would defeat, like I said in the brief, the whole point of the statute is you're not allowed to drunk carry. Intoxication goes to your knowledge. You'd be able to defend and say...
But what's the danger of someone drunkenly possessing an unloaded gun?
That's not a crime.
I understand that's not a crime, but you're telling me that the defendant's knowledge of whether if he completely reasonably thinks the gun is unloaded and then has a few beers, that's a 2.5-year crime, even though it was perfectly reasonable for him to think it was unloaded. Why would the legislature want that?
Because the whole point of the statute is to prevent people from discharging a firearm while they're intoxicated. It's a safety,
Which would be tough if the gun wasn't loaded, right?
To discharge it?
Yeah.
Well, that's also not a crime. That's not an offense. But again, the plain text doesn't have this knowledge component. The Brown case is not a reason to read knowledge into the statute because there's no lesser included offense here. The Brown case is not hopeful. And then the other point is that, setting aside Brown, it's not a strict liability statute anyway because your intoxication for this type of offense has to be voluntary. So if the concern is that we don't...
Why does it have to be voluntary? I don't see anything in the plain text that says whoever voluntarily under the influence.
I think the court has construed like the OUI statute to have that as a requirement. So I'm bringing that over from the OUI cases to this statute because it would seem as though that's what the rule is for drunkenness offenses. Because
so how do we decide when to use the plain language and when to import concepts from other statutes, like the concept that the loaded needs to be known, which is a pretty consistent through our gun laws?
Well, the reason that 10 sub N has been construed to have knowledge that the gun is loaded is that 10 sub H is said to be a lesser included offense of 10 sub N, and 10 sub H requires knowing possession of ammunition. And so, that's the reason why Brown comes out the way that it does. But again, our statute doesn't have that. Our statute doesn't have that lesser included offense structure. And I would submit any due process concerns on putting a judicial gloss on the statute to add an extra element doesn't really exist here because it's not a strict liability statute anyway, because your impairment must be voluntary. So if someone slips you some drugs that you're not allowed to be under the influence of, you're not committing, and then you're carrying a loaded firearm. You're not violating the statute.
Why should we depart from the plain language to add voluntary intoxication when instead we could just depart from the plain language to add knowledge of loaded and achieve the same result? Why should we pick one over the other?
Well, the court already has with respect to voluntary intoxication. So that's already established.
For the statute?
I think it's already established for OUI. And so the impairment element here is the same. I believe I cite to a drunk driving case for that proposition. So because this statute also under the influence of alcohol or drugs, it would seem as though a judicial construction requiring voluntary impairment would also apply to this statute. Also, I believe that this statute was enacted much later than the OUI statute, and the legislature presumably knows about judicial construction of the OUI statute. So there's no need to import a different knowledge or different mens rea into a different element of the statute, or really to make up an entirely new element, especially since, as I said, it leads to the absurd result that a person could be so drunk that they're not violating this statute even though they're carrying a loaded firearm, because they could say, I didn't know that it was loaded because I was too intoxicated. And given the purpose of the statute is to ban people from doing this exact activity, it doesn't make sense for it to be a defense, which would necessarily be the case given the way that knowledge and intoxication interact. So that's why you shouldn't impose that as an extra element. Even if we had to prove it, I would submit we proved it anyway. The defendant clearly knew that he had a gun on his person. He told the trooper it was in a holster. He was a legal gun owner. There was no objection to any of that testimony coming in. Plus, he also had another magazine, I believe, in the glove box of the car.
I didn't see any citation in your brief to a case that says owning parallel magazines makes it more likely that you knew that the firearm you were carrying was loaded. Is there something similar to that?
So I would basically say that I'm relying on Resende, because Resende says if you put a gun on your person, it's reasonable to infer that you would have checked before putting it there that it was loaded, plus other factors. And the other factors in this case are he's a legal gun owner and he has a magazine in the car, which shows familiarity with firearms, which I believe was a factor in Resende in finding on that record the evidence of 10 sub N was sufficient. So that's my answer to your question.
Thank you.
Do you stand by your view that the facial challenge is preserved?
Well, this case was tried before Bruin was decided. I don't see how he could have made a facial challenge because the legal standard in Bruin didn't exist when this case was
Why
tried.
couldn't you make a facial challenge under Heller and McDonald to a law that prohibits you from even having a gun in your home if you're drunk?
Well, I think that Bruin really changed things for the Second Amendment. It gives a lot more content to the Second Amendment standard. So it is interesting, though, that I don't know how the defendant could have precisely made the argument that he's currently making on appeal before Bruin came out, because I don't think anyone predicted that the Supreme Court would come up with the Bruin standard. So this is largely in fairness to the defendant, because I don't know how he was supposed to know that the Bruin case would come out as it did.
Yeah, it had already been argued, but I still think it surprised us. It had already been argued, but I still think it surprised us.
Well, yeah. Well, we never really know what's going to happen. So, I mean, but your point's well taken. And now I'm out of time. Unless there's anything else, I'd ask you affirm.
All right. Thank you both. It's a really fascinating case. We'll take it under advisement. We are going to take a 15-minute break before we hear the last two cases. The last two cases are child custody cases, but I urged all the interns to stick around because we will be talking with you after all the arguments are done. So hopefully most of you will stay. We'll be back in 15 minutes.
Session concluded.
All righty. Call the next case, adoption of children, number 25P820. I'll remind everyone that we won't be naming any of the civilians. We'll use terms like mother, oldest of the subject children, middle subject child, youngest subject child, those kind of things. All right, whenever you're ready, Counselor.
Thank you, Your Honor. Thank you, Justice. My name is Mark DeJoy. I represent a mother who is appealing the court's violation of her due process rights, not because the judge's actions are not allowing the continuance, because of the judge's inactions are not following settled case law that this court has made in the SJC and Edmund, Whitney, as well as Patty. The facts of the first day of trial, mother did not appear but was speaking to her lawyer. The judge was conveying and representing to the court that mother was in a detox program and had been there since November 20th. The first day of trial was on November 25th. Mother asked counsel to continue the case, and the judge denied that and asked for the department to call their first witness. Here's where the judge had the opportunity to be flexible, as Edmund and Whitney say, to come up with alternatives to allow the mother to participate in the trial. The judge had the opportunity, because she was communicating through counsel to the mother, that could have told counsel to go figure out how to get a telephonic communication at the facility. Could have asked for a Zoom call. These are all things that Edmund lays out.
Was there any request for that kind of accommodation?
There was not, Your Honor, by counsel. The second day, if I could, Your Honor, the answer is no on both days, but on the second day of trial, mother again was communicating, but had told the judge, had asked counsel to withdraw because they were having communications issues. So at that point in time, the judge denied the continuance again, and then would not, because of it would leave mother at a disadvantage not to have a lawyer while she was in the rehab place.
Did the judge find that the mother was actually in the rehabilitation facility that she represented?
Your Honor, there was a picture of a wristband. I can't tell from the record if the judge ever looked at that. The counsel for mother was waving it out of his phone. The judge then, about two pages later, says, I know that's your representation, so I can't tell if she doesn't believe the lawyer or she doesn't believe the client. But I think it was the latter as opposed to what she was doing. With Patty, Your Honor, which is well, let me go back, Your Honor. Mother has not abandoned the case at this point pursuant to Rory. She's participating, maybe not how the judge likes it, but she's communicating at 9 o'clock in the morning just when it's time to be there for trial. She does that on the second day of trial, Your Honor. The funny thing, Your Honor, on the second day of trial, while the judge could have had telephonic communication, Zoom, the judge also had the option with Whitney to say, you can do post-trial depositions, you can do an affidavit, she could have said, why don't you go listen to the tapes, come back and give me a written rebuttal. In fact, the second day of trial, she kept the evidence open. So there was some late exhibits that she gave counsel the opportunity to file motions in limine. So the evidence wasn't closed as of the November 26th. She had 2 more weeks. The judge had a perfect opportunity, the judge, to say, use the roadmap given by Whitney and Edmund to say, go do A, B, or C.
You've mentioned Whitney a few times, but I don't see it cited in your brief. Do you have a cite to it?
I do, Your Honor. I do. Your Honor, if I could get it for you, I'm throwing here. I do have it. I know it wasn't in my brief, Your Honor, but I found it since my brief. I could send it to the court what the brief is. But it's clear that Whitney allows the judge, or actually mandates the judge to come up to use that roadmap to protect it. Further violating her rights is that the judge then took a negative inference of a mother not testifying. The judge has the opportunity to correct this, even if mother does not show for whatever the next step the judge allows her to do. I would hold, Your Honor, that the judge is in the best position to decide how to protect mothers' due process rights. In fact, according to Patty's, in those cases, she's mandated to do so.
Does it matter that if the judge found that the purpose was not genuinely because the mother was unavailable, but because it was a dilatory tactic?
Your Honor, the dilatory tactic has been in that case for 6 to 8 months. So I think there is a difference, Your Honor, because at this point in time, the mistrial, from the first 8 days of mistrial, parents didn't show up and mother didn't show up. At least the day of trial, the first 2 days of trial, mother is communicating to the court. It's a little bit different than dilatory. Now the judge has her. She's already saying, I'm not going to continue the case, and that's the perfect opportunity for the judge to give the mother an opportunity through counsel who's there to say, this is what I'm going to do for you, and you have 2 weeks to do whatever you think you need to do to rebut or offer evidence.
I read your brief as arguing that the judge violated the mother's due process rights by not continuing the case. I don't see where your brief argues that the judge erred in taking an adverse inference against the mother. Where does it say? But I think I just heard you argue that. Does it say in your brief that the judge shouldn't have taken an adverse inference?
I don't believe it does, Your Honor, but the judge has the opportunity there to protect. All the judge had to do was say A, B, or C, or D, and so it's not in my brief, Your Honor, but it's the judge, the due process rights, whether I argue or not, Your Honor, if it were violated, then that's kind of, that's my client's position. If there are any questions, I'll rest my brief.
All right. Thank you, Counselor.
Thank you.
And we have the cite to Whitney, so we're all set.
Thank you, Your Honor.
May it please the Court, Claire Gilchrist for the Department of Children and Families. We are asking you today to affirm the orders of the lower court terminating mother's parental rights to the subject children. At the outset, mother has not challenged any of the court's 284 findings of fact. As such, they should be left undisturbed, and they amply support the termination. I'd like now to address the due process arguments raised by mother. There was no due process violation here. Due process does not mean that a parent can continue delaying a trial for 2 years. Here, mother had notice of the trial date. She had the opportunity to appear and to be heard. She was represented by counsel who made objections on her behalf, examined witnesses, and filed motions. I'd like to correct the date that she claims to have entered the inpatient facility was November 5th, not the 20th. So this was 3 weeks before trial. She made no attempt whatsoever to communicate to the court prior to the morning of trial that there was a potential conflict here. She made no attempt to make any arrangement to participate in any other manner. There's no evidence that she couldn't leave the facility and come to trial if she was in fact at such a facility. And she was at the facility voluntarily. This was not an involuntary incarceration, which is the cases that my brother cited, which are not in his brief. This appears to be a new argument this morning that's not been briefed.
How do we know that it was voluntary? I mean, just in the abstract, it probably is. But is there evidence that it was voluntary?
Well, that's part of the issue here is there was no affidavit to support mother's motion. She provided no evidence about the circumstances of her request. So nowhere is there mentioned that this was a Section 12 involuntary commitment. And that's part of the issue. That this judge, it was within her discretion to look, to hear this motion and say, I have nothing here. There's no affidavit. There's no medical note. There's nothing to support what is being offered. And furthermore, again, going back to the timing, and if we look at care and protection of Quinn, that it's amply within the judge's discretion to look at the timing of the motion, whether there was an affidavit, and then the pattern of delay which is, trial was first scheduled for June of 2022, and then it finally happens in November 2024. And that is largely continuances that happen on behalf of mother, either at her request or for her benefit. And, we know that these types of cases with children involved, it's very important that they're timely decided. The juvenile court standing orders say that these cases should be resolved between 12 and 15 months. Here, this case was almost 4 years old, and the trial was delayed 2 years, but the whole care and protection had been ongoing for 4 years. Mother missed 22 court dates in those 4 years, and she had benefited from 7 continuances already prior to trial. And her, again, not providing any kind of documentation. She didn't move to reopen the evidence, and I'm hearing from my brother, the evidence was kept open. She didn't submit any documentation at that time. She didn't move for a new trial. And I'm relying on what I'm hearing just today about Edmund and Whitney, because it was not briefed, that, those cases, I believe, sorry, now I've lost my train of thought, I apologize. But those cases are distinguishable. Those parents,
Edmund was the incarcerated father.
Incarcerated father. He
wanted to participate
He wanted to participate. He had requested, far in advance, and he persistently requested to participate. And there was a telephonic issue on the day of the hearing, so there was a technical issue. Same thing with Patty. There's a technical issue. There's no such barrier here. It's simply mother not appearing. And then her request to, on the second day, have a different attorney. That is a delay tactic. And the judge, there is evidence that was a delay tactic. It's not an abuse of discretion for the judge to see that as part of a pattern where mother had multiple times previously requested withdrawal of counsel and then reappointment and so forth. And she knew that this is something that could potentially work. But the judge, examined all the factors relevant to the decision. She considered whether good cause had been shown, and she considered the prejudice to mother of allowing her attorney to withdraw in the middle of trial, and denied that request.
Counselor, we have we have our labeled volumes 4 and 5 of the transcript, but it seems like that was the whole trial. What's volumes 1, 2, and 3?
I believe that perhaps those are the record appendix, documentary evidence?
No, the transcript, it says on the top, volume IV, 4, and then the one for the second day says volume V on the top, which makes me think someone's transcribed 3 other volumes that we haven't been given.
I didn't assemble the record.
Do you have
or
the other?
I have not seen transcripts of any other hearing dates.
You were given just the 4 and 5? Did you get it from the father's appendix? Or did you get transcripts independently?
I did not request them independently. I relied on what mother's counsel filed.
Mother, yes, sorry. All right.
So I have. Okay. If there are no further questions, I rest on my brief.
Thank you, Counselor. We'll hear from the child now.
Good morning. My name is Sandra Ferrigno. May it please the court. I represent the children. They are requesting that this court affirm the decrees of the lower court, finding the parents unfit, terminating their parental rights, and freeing them for adoption. The original petition included 5 children. The two oldest children have since turned 18, so the 3 children remain. I will refer to them as children 1, 2, and 3. Child 1 is 16, child 2 is 11, and child 3 is 8 years old. The court's discretion not to continue the trial was exercised against an extraordinary backdrop of mother missing numerous court hearings and trial dates from the inception of the case in 2021 through the trial in 2024. The 2 judges themselves had continued the trial dates 7 times overall. When Mother's Counsel sought yet another continuance on both of the November trial dates, the judge was not required to credit counsel's representation and the photograph of the hospital bracelet, especially, as you have heard, with no supporting affidavits or other admissible evidence. The judge had discretion to weigh it against years of inconsistent attendance and delays by Mother. This was not an emergency. As you have heard, Mother was reportedly in the residential treatment program for 20 days prior to the first day of trial. And there was no evidence that she had let DCF know where she was or that she had communicated with trial counsel prior to that first morning of trial. This was simply one more in a series of unverified health-related reasons to delay the trial. The judge properly balanced Mother's asserted reasons for a continuance against the children's paramount interest in permanency. The denial of the continuance was in the sound discretion of the trial judge. And not to belabor the point, both with respect to due process, Mother was not denied due process here. Due process does not entitle a parent to endless continuances. The focus is whether the parent had an opportunity to be heard in a meaningful way and in a meaningful manner. Mother had notice of the trial. She was in contact with her counsel. Her counsel fully participated in the trial by cross-examining witnesses, making objections throughout the trial, conveyed Mother's position to the court, and filed written motions in limine. Physical presence at trial is not a per se due process requirement. Nor would the outcome of the trial been different if Mother had been allowed to testify, as she contends in her brief. Mother did not file any post-trial motions and made no proffer of what her testimony would have been at trial. Given the overwhelming uncontested evidence of her unfitness, neither her testimony nor a continuance or allowing of the continuance would have affected the outcome of the case. Mother does not contest her unfitness or any of the court's findings. The judge found unfitness based on a constellation of factors, which included Mother's 24-year history with the department, her unaddressed mental health and substance misuse, lack of compliance with DCF's action plan, and lack of insight and understanding into the children's significant needs. There was ample evidence in the record to support a finding of parental unfitness by clear and convincing evidence, and that her unfitness was not temporary. The children have been in DCF custody for nearly 4 years. Each of them came into care with serious medical, developmental, and emotional needs, and that went unrecognized and unmet in Mother's home. At the time of trial, Child 1 functioned years below her grade level, and she was kept from medical care that was approved by her doctors because Mother objected. Child 2 carried several significant mental health diagnoses, and Child 3 is in a pre-adoptive home where she wishes to remain. Affirming these decrees will free Child 1 and Child 2 to find that same permanency. I therefore ask that this court affirm the decrees.
All right, thank you,
No
Counselor.
questions? I rest on my brief. Thank you, Your Honors.
Thank you all. We will take the case under advisement. It's been very helpful. Thank you. Take your time. There's no rush. All right, so I need to call the case for the record. The case is adoption of child number 25P1406. Because we want to keep the name of the child confidential, we won't name the child, and I would ask you not to give your own name because that would give away the child's name as well. So, we'll use words like child, mother, great aunt, stuff like that.
So initials aren't acceptable?
I'd prefer not initials.
Okay.
All right, so you've got 15 minutes whenever you're ready.
Okay. Hi, good morning, Your Honors. My name is, I won't say, but I am the child's great aunt, and I appear before the court pro se. And please forgive me, I have a little bit of a head cold, so I might sound a little off. But this appeal presents a single procedural question: whether the juvenile court abused its discretion by denying my motion to intervene after the Department of Children and Families approved me as the child's adoptive resource, completed the ICPC process, developed a transition plan, and scheduled the child's placement in my home. This appeal is not about whether I should receive custody. That determination belongs to the juvenile court. Rather, the question before this court is whether I should have been permitted to participate as a party before that determination was made. For more than 3 years, I maintained a consistent and substantial relationship with minor child. My involvement began shortly after her birth, while she was in the neonatal intensive care unit. Over time, DCF steadily expanded my role. I attended medical and therapeutic appointments. I participated in services. I completed every requirement requested of me and prepared for her permanent placement. Most importantly, DCF concluded that the minor child should be placed with me. The department completed 2 ICPC approvals, designated me as her adoptive resource, developed a transition plan, increased visitation, approved overnight visits, and established January 24th, 2025 as the anticipated placement date. The record contains exhibits documenting each of those events. Despite those actions, I was denied the opportunity to participate in the proceeding that ultimately determined whether that placement would occur. The juvenile court denied intervention largely because it believed my interests were adequately represented by existing parties and because of concerns regarding permanency. Respectfully, those considerations do not replace the analysis required under Rule 24. First, whether I possess a substantial legally protectable interest. Second, whether denial of intervention would impair that interest. And third, whether my interests were adequately represented by the existing parties. Each requirement was satisfied, Your Honors. First, I possessed a substantial legally protectable interest. My interest was not based solely on my biological relationship to the child or an emotional desire to adopt her. DCF twice approved me through the ICPC process, selected me as the minor child's adoptive resource, completed a transition plan, and prepared her for permanent placement through increasing visitation, including overnight visits in my home. These facts distinguish this case from those involving relatives asserting only a generalized concern for a child's welfare. The juvenile court's decision directly determined whether the placement DCF had planned would occur. Accordingly, the judgment directly affected my legally protectable interest. Second, Your Honors, denial of intervention impaired those interests. As a non-party, I could not present evidence, examine witnesses, introduce exhibits, object to testimony, or otherwise protect my interest during the proceeding that determined minor child's permanent placement. Before the best interest trial, DCF's actions, including preparing for my placement, involving me in transition planning and identifying me as the adoptive resource, reasonably led me to believe that my interests were being advanced. Under those circumstances, there was no reason to believe intervention was necessary earlier. Only after the adverse ruling, when DCF elected not to appeal, did it become clear that no existing party would protect my individual interest. Once judgment entered, the opportunity to participate in the proceeding determining permanency had been lost. The impairment was therefore complete. And thirdly, Your Honors, my interests were not adequately represented. The appellees argue that DCF adequately represented my interests because it sought the same placement outcome, but respectfully, shared objectives do not necessarily constitute adequate representation under Rule 24. DCF represented the Commonwealth's interests pursuant to its statutory responsibilities. It did not represent my individual legal interest. As a non-party, I had no authority over litigation strategy, witness selection, evidentiary decisions, settlement decisions, or whether to pursue an appeal. Most significantly, after the adverse ruling, DCF elected not to appeal. At that point, it became clear that no existing party would protect my interest. The trial court also relied on the participation of DCF, the child's counsel, and the guardian ad litem. Each does serve an important but distinct function. DCF advances the department's permanency plan. The child's counsel represents the child's legal interest. The guardian ad litem provides an independent assessment for the court. None represent the distinct legal interests of a kinship caregiver seeking intervention. The Rule 24 inquiry is not whether other participants are present. It's whether they adequately represent the applicant's individual interest, and here they did not. The appellees also contend that my motion was untimely because it was filed after the best interest decision. Respectfully, timeliness must be evaluated in context, Your Honors. I was not a party to the proceeding. Following the decision, I contacted DCF regarding further review and reasonably believed additional proceedings were being considered. Once it became clear that DCF would not appeal and that no existing party intended to protect my interest, I promptly filed my motion to intervene. Under those circumstances, my motion was filed at the earliest practical opportunity. Finally, this case is consistent with Massachusetts' longstanding policy favoring preservation of family relationships whenever possible. DCF followed that policy throughout the case. It evaluated me, it approved me, they trained me, and ultimately selected me as the minor child's adoptive resource. This appeal does not ask this court to determine where the minor child should be placed. That determination belongs to the juvenile court. I ask only that this court hold that the person DCF selected as the child's permanent placement was entitled to participate in the proceeding determining whether that placement would occur. Because I demonstrated a substantial, legally protectable interest, because denial of intervention impaired that interest, because no existing party adequately represented my interest, and because my motion was timely under the circumstances, the juvenile court abused its discretion. Accordingly, I respectfully request, Your Honors, that this court reverse the order denying intervention, remand the matter for further proceedings with me as a party, and grant such further relief as the court deems just and proper. And thank you, and I welcome the court's questions.
I have a few questions. One is, if you were allowed to intervene, what would you be able to do at this point where the adoption plan's already been approved?
Let me just get my cheat notes for these questions.
Sure.
I am seeking reversal of the denial of intervention and remand that permits meaningful participation in proceedings affecting the minor child's placement and family relationships. I'm not asking the court to decide placement directly. Let me see if there's any other. A remand for the application of the correct Rule 24 standard, including proper analysis of the appellant's kinship interest, independent evaluation of whether any party adequately represent that interest, and a determination without collapsing analysis into permanency or procedural postural concerns. I basically just want to be able to have a voice and be involved in the decisions moving forward.
All right. Is there a reason you didn't file a guardianship action in the probate court?
Oh, you mean at the beginning I tried and I'm out of state, so they just felt that because I was out of state, I actually tried to intervene. Actually, I asked DCF, and I think that was a recommendation, like you could go to the probate court. Is that what you mean?
Yeah.
I tried that, and because I lived out of state, and they were just like, they felt like, let DCF handle this, is what I was told. But I mean, otherwise, I would have done that. That's what I was trying to do, and unfortunately, it didn't pan out the way I was hoping.
I understand. I don't think we have any more questions, so if you're done, we can hear from the department.
Thank you so much.
Thank you. Whenever you're ready, Counselor. Oh wait, actually, hold on a second. Let's let the great aunt get situated again. Do you have your water back? Okay, great. Understandable. All right, now we're ready. Whenever you're ready.
Good afternoon, Your Honors. Robert Fairbairn, and may it please the Court. Robert Fairbairn on behalf of the Department of Children and Families. Your Honors, the lower court did not abuse its discretion when, 74 days after the conclusion of a competing planned best interest trial that would determine where a child would be placed under adoption, the trial judge denied the great aunt's motion to intervene.
Could you speak up a little or move closer to the microphone?
I'm sorry, Your Honor. Not only was this motion untimely, Your Honor, it failed to meet the requirements for intervention under Rule 24A or Rule 24B. Your Honors, Rule 24V governs intervention by right, and it provides two distinct avenues for the invocation of that rule. The first is there's a constitutional or statutory right to intervene, and the second is that a party has an interest, that interest may be adversely affected by the outcome, and that no other party adequately represents that interest. Your Honor, the great aunt claims both those avenues. In terms of a statutory or constitutional right, the great aunt relies on two sections of Chapter 119, as well as 4 sections of 110 CMR. Your Honor, the great aunt relies on Section 23C of Chapter 119, which places the burden on the department to find a kinship placement as soon as possible or give priority to them after assuming custody. It does not, however, grant rights to kinship over other parties in any proceeding relative to the child's care and custody. The second section is Section 26, Your Honor, which deals with the court's determination and weighing of adoption plans. It notes that the trial court must make a determination in the child's best interest. It does not give preference to kin. It does not give preference to the department. It does not give preference to any party. It's simply a balancing test. Thus, the great aunt has no avenue under that particular section, Your Honor. Further, her reliance on 110 CMR 7.0 through 7.3 is equally misguided. Each one of those deal with either services provided families, pre-adoptive licensing requirements, subsidies for pre-adoptive homes, or sponsored guardianships, none of which would confer a right to the great aunt to intervene in the underlying proceeding. In terms of the second road, Your Honor, which is that a party has an interest that is not adequately represented, I would suggest that she must fail under that path as well. Your Honor, when one party is charged by law to represent the interest of another, adequate representation is assumed. The great aunt was the department's placement. Further, Your Honor, unity of interest is not, they had the same interest.
So you had the same interest for much of the litigation, but by the time the motion to intervene was filed, DCF had determined not to appeal, and the great aunt wanted to appeal. So why are your interests congruent at that point?
Well, Your Honor, I think the issue ultimately arises from her dislike of the underlying adjudication.
Sure.
She was not a party to that litigation, but her rights were, she has no grounds and no standing to lodge and intervene and attempt to lodge an appeal. Her interest insofar as she was kinship seeking to be adoptive resource was represented by the department. In that interest, they had a unity of interest, but as this court has determined, unity of interest is not the same as unity of argument. As long as the department vigorously defended its position and asserted its position in support of the great aunt, the fact that the great aunt would have chosen a different litigation strategy doesn't change it. The fact that a party would have chosen a different litigation strategy does not render the department's actions ineffective. Also, and the same applies to an adverse determination. The department put forth this evidence, child put forth this evidence, and the trial court made its determination. Equally unavailing, Your Honor, would be a permissive intervention under Rule 24B. That holds that a party has a common factor interest in engaged, and that fundamentally their intervention would not be untimely, would not unduly burden or delay proceedings. Here, Your Honor, there's sort of two elements to that. The first is any post-trial motion to intervene is necessarily going to be untimely. But even if we were to overlook that fact, the great aunt's intervention would seek to overturn the underlying adjudication in favor of the child's proposed adoptive resource. This had been an ongoing care and protection for several years. And as this court noted in Rashida, no other cases require an expedited nature more than a child welfare case. After almost three years of litigation, the trial court determined the child's permanent abode. So our argument would be, Your Honor, the trial court, with that in mind, did not abuse its discretion in finding that the great aunt's intervention under a permissive section would unduly burden the litigation and unduly delay permanency for the child. Finally, Your Honor, in reference to the motion being untimely, the great aunt knew or should have known that her rights were adversely affected. I appreciate that she relied on the department, but she had an independent interest if she sought so. She should have intervened. Also, the great aunt, by her own indication, had been a party to the action, had known of the action since its inception, and at no point prior to that trial sought to intervene. So with that, Your Honor, if there are no further questions, the department will rest in its brief.
All right. Thank you, Counselor.
Thank you, Your Honor.
It's afternoon.
Let me first say good afternoon, Your Honor, and may it please the court. I am Michael Penton. I represent the appellee child who requests that this court affirm the juvenile court's denial of the appellant's motion to intervene and permit child's adoption to proceed without further delay. In my limited time, I'd like to focus on the areas of the rules that specifically speak to the child's best interests. First, whether delayed intervention prejudices child, which child submits it does, and whether appellant has demonstrated she has an independent cognizable interest compelling her intervention, which child says she does not. The lodestar of child welfare matters is the child's best interest, and achieving stability, permanency, and finality is chief among those. Child will be grossly prejudiced if the intervention is allowed at this stage. Child is now over 4 years old. She's been in DCF custody since she was 2 days old. She's been in the pre-adoptive home since she's 2.5 months old. She's been freed for adoption for the past 2.5 years. She's been in a court-approved adoption plan for over a year. The department, as the child's permanent custodian, has accepted the judge's decision. And frankly, the time to appeal that decision has long lapsed. And as Justice Ditkoff had mentioned, what's the next step if the intervention were to be allowed? I submit there is no next step. Conversely, the appellant's plan or aim is to start the best interest process anew. Even pending before this court is a motion for a new judge, which would entitle or have years' worth of possible delays for the child's permanency. On the second point, the appellant has failed to establish she has an independent, cognizable interest that would entitle her to intervene. And there's no question she loves child and her intentions are well-meaning. But a biological connection alone does not establish an interest warranting intervention. I think the most generous designation, as we've set forth in our brief, is that of a foster parent or a pre-adoptive parent or a relative giving care. While we're not conceding it would fall into any of those categories, that is probably the most appropriate for this purpose of this argument. And as the legislator has spoken, that designees who occupy those titles are entitled to notice of a hearing, are entitled to opportunity to attend the hearing, and to be heard. But the legislature has specifically said that they are not entitled to party status. And the reason why is the interests of the parties intervening is surrounded by, or encompasses and occupies, the child's best interest. Not because it's a separate interest, but it's to inform the court the well-being of the child on a day-to-day basis. Who's best equipped but the child's day-to-day caretaker, who are usually a foster parent, pre-adoptive parent, or a relative giving care. Even if this court were to entertain a limited intervention for ancillary issues like post-adoption visitation, the judge has addressed that. First and foremost, the visitation is always in the child's best interest. That is the guiding line, not what is in a relative's best interest. In this case, the judge had addressed that specifically, saying the child has advocates.
When you say visitation is always in the child's best interest, you mean judges consider the child's best interest in determining visitation?
Correct. So while there may be mutual that a relative would have an interest in it, if it's not in the child's best interest, it's not warranted.
Right. It sounded like you meant always visitation should be allowed because it's in the child's best interest.
Oh, no, I apologize for the misunderstanding. I mean that the child's best interest is the guiding light, and regardless of anything else. And the trial judge has addressed that when she denied the motion, saying that there's a court-appointed guardian ad litem that is addressing the child's visitation issues. Child has court-appointed trial counsel that is in a position to address the interests. And also, the adoptive parents, like biological parents, are presumed to act in the child's best interest. And again, the term biological relative can be thrown around, but there is, members of a biological family that have heightened status, siblings, grandparents. The legislature has enacted statutes that allow them to pursue visitation, establishing de facto parentage, as Justice Ditkoff alluded to, a guardianship or from a guardian. So there are recognized members of a biological family that have a separate and cognizable interest towards post-adoption visitation. But again, the guiding principle is the child's best interest. So establishing all of those points, there is no basis for this court to disturb the trial judge's denial of the motion and to affirm that motion. And if there are no further questions.
Is this appeal the only thing standing in the way of adoption, or are there other things?
Legally, it shouldn't be. Practically, it is.
I'm sorry, could you say that?
Legally, it should not be, but practically it is.
I understand.
Judges, of course, are reluctant to take action while there's an appeal pending, whether there's no action of a stay pending, but certainly, it's hard to put the toothpaste back in the tube if this court decides, makes a decision different than what the trial judge has already decided. I believe my brother has covered the rest of the basis. If there's any questions for the panel.
All right. Thank you.
Thank you.
Thank you, all three of you. We'll take this under advisement. That concludes our sitting for today. I'd like to thank the court officers who usually don't get quite the workout they get when we have this kind of crowd, our timekeeper, the clerk's office that enables everything we do, all the attorneys today, our self-represented party, actually two, we had two self-represented parties today. And I'd like, of course, to invite all the interns to stay afterwards. We're going to hop off, take off our robes, and come back out and talk to you. I'd certainly prefer that it just be the interns and their people who escorted them here, and not the parties. And with all that said, court will be adjourned until tomorrow at 9:30, when we'll have a very special induction sitting for Justice Hillman. Thank you.